Hello, everyone. This is Thomas Rivero. Thanks, everybody, for joining, and welcome to today's webcast. It's titled Data Privacy and Why It Matters. So this webcast is sponsored by the Storage Network Industry Association's Data Protection and Privacy Committee, otherwise known as the DPPC. I'm Thomas Rivera, co-chair of the Data Protection and Privacy Committee, and I'll be your moderator today. So let me provide a quick overview before we begin. Today's webcast is designed to encourage audience participation. So what we're going to do is we're going to provide a short briefing on data privacy and why it matters. We're going to compare GDPR and CCPA, and we're going to focus actually on one specific area, and that area is the right to be forgotten. After the briefing, we'll move into a panel discussion, and at the end, we'll have a link to this webcast recording for those that want to listen to it at a later time. That link will be on the SNIA.org website. So what we'll do then is allow people to ask questions after the briefing. We'll have sort of a panel discussion, and in a manner to keep the flow going, I will moderate the discussion and make sure we get questions from the audience, and then have that discussion as we move along. So what I'd like to do is to have just a couple of introduction slides here. There's a little bit of a legal notice. We do actually have an attorney as one of our panelists, but just to make sure it's understood, we are not giving legal advice. So if you do seek legal advice in any of the matters we discuss during today's webcast, please consult your attorney. A little bit about the Data Protection and Privacy Committee is listed on this slide. So our main charter is really to educate the end user community on things related to data protection as well as privacy, specifically data privacy. And if you're interested in joining, we have information available on the URL that's on this slide at the very end of the slide. So feel free to look at that, and we also have some resources available, additional resources on the website as well if you're interested. So there's going to be a couple of panelists, and you'll see those on the screen right now that we're showing, as well as me, the moderator. And then, again, we're going to go through a short briefing, and after the briefing, we'll have the panel discussion with our panelists and allow the audience to ask questions through the Ask Questions button that'll be listed on your screen. So before we continue on, I just wanted to let you guys know that we're going to start with a quick briefing like I mentioned before, and then we'll move on to the panel discussion. So we'll start the briefing right now, and then we'll move on to the panel discussion afterwards. So to start off, we wanted to do a little bit of a summary of what data privacy is. From an EU perspective, it's really mentioned as, or really considered a fundamental right, and in some parts of the world, it's kind of regarded as an element of, liberty and the right to be free from any intrusions. It's really in the U.S. really more considered or referred to as a legal concept, this term privacy, and then data protection deals with more of the technical aspects of how you deal with protecting the privacy of individual people. So the interesting takeaway here is that privacy is really dependent upon security. Conversely, however, security is not dependent upon privacy, and that's an interesting concept to make sure that's understood. We'll probably talk a little bit about that during the panel discussion as well. So when we talk about data protection here in the EU, specifically for the European Union, they have what's known as I'm sure many of you know, the GDPR, otherwise known as the General Data Protection Regulation. From that perspective, in the EU, data protection is defined as protecting any information relating to an individual, more or less. that it really includes information like names, birth dates, photographs, video footage, email addresses, telephone numbers, and the list goes on actually. But those are some of the major pieces of information that would be considered protected as part of the data protection regulation as it's stated in GDPR. That was really adopted just a couple of years ago, and it has been enforced for the last few years, that being GDPR. And then we're going to talk a little bit about PII, or personally identifiable information, as it's termed within the EU GDPR regulation. So if we try to define PII, this is actually from the ISO 29100 ISO document. It goes into how folks are identified from a personal information standpoint. It could be related to things such as information like data that has to be protected. That you'll often hear the term data subject, and that's really, data subject is used as a term within the GDPR quite a bit. Another way of saying that for common use is an individual, and within that individual then you have the ability to protect that data, and there are specific types of information related to an individual that is protected according to GDPR. The interesting thing is it has some items in there that is a little bit new to many of us. So for example, a piece of information that's protected, again as PII, is things such as IP addresses, not just dates of births and names and addresses and so on, but interesting things like internet subscriber might be considered PII. Why? Because the idea is you can, in some cases, relate a given IP address back to an individual. So as far as GDPR is concerned, the way it's written, that's considered PII. Any comments there on that one, Eric?
Yeah, that's definitely one of the problem areas of complying with GDPR is the breadth of details that you essentially have to protect. It's much broader than in the past. Things like photographs and whatnot. So if you're in Europe and taking pictures of people, you might actually be asked to not post that, or if you do post it and they see it, they might ask you to take it down because it's PII.
Right. An interesting point. And that action of asking to take it down, it's that GDPR has this concept of the right to be forgotten. One of the things that we're actually going to focus on today, and that's what Eric is referring to, is someone that might come along and say, hey, company XYZ, please, I notice you have my photograph on your website, just as an example. Please remove it. And that's that whole right to be forgotten as it's listed in GDPR, which we'll talk about a little bit later. Any other comments from you, Stephen?
At the moment, no. I got caught up in a client matter, and I apologize for being a little bit late to the gate. You know, the right to be forgotten for a photo raises an interesting question, and that is, if the photo is somehow used to conduct the transaction, and that's something that has to be retained as a matter of your business needs rather than, you know, just a personal information collection, then perhaps, you know, that may fall under an exception.
Good point.
Yeah, possibly, although the GDPR is a little less forgiving about that. But the kind of scenarios that I've heard of that come up is, you know, somebody is off work, you know, they're sick, and pictures go up of, you know, the great party on the sick day. And you actually have the ability to make stuff like that go away.
Well, and there's also a question of, how do you, well, we can get into verification later, but how do you know that the person making the request is the person who has the authority to make the request?
Yeah, that's definitely something we'll talk about, I think, in the panel discussion, because there's some interesting differences between GDPR and CCPA.
Yeah, that's a good point. And we'll actually mention some of those differences specifically with CCPA in a minute. So I'll just go on to the next slide. Just generally, some of the drivers for data protection are obvious things. Just the fact that the growth of data is phenomenal. A lot more compliance nowadays than it was in years past. Certainly the number of breaches, but as well as the cost of data breaches has skyrocketed as well as the increase in the data value. I won't go through all the entire list here, but you get the idea that there's a whole bunch of things why it's important to protect data. Some of those challenges are what's listed here. Again, I won't read the slide to you, but basically you have a bunch of challenges. And the takeaway here is that they're from the perspective of protecting the data, especially from a company perspective, companies really in general are pretty much still behind the curve in data protection readiness, and that's really the takeaway. And I think there's a lot more work to do, and some of the things that we foster as best practices is still required to be put into place. So, from the GDPR and PII, we sort of mentioned this a little bit more. There's a whole bunch of different topics related to data privacy within GDPR. I listed them here as sub-bullets. So, for example, requiring the consent of subjects for data processing. So you have to have consent to actually process and retain specific data. There's always going to be exceptions to these, by the way, but these are general rules. Anonymizing collected data to protect privacy, things like the need or requirement actually within GDPR to do notifications if there is a data breach, and what constitutes a data breach, which is kind of interesting. We might want to get into that a little bit later. And then just one of the last ones here is just the right to be forgotten, where the regulation actually allows you within GDPR to specify as an individual, because you're, in this case, an EU citizen, a European Union citizen, that you want your data deleted. Again, the common term, right to be forgotten.
Yeah, so Thomas, just a comment on that. It's actually broader coverage than just EU citizens. So if you are, for example, a U.S. citizen in Europe, you are granted those protections while you're in Europe. So it's kind of fascinating that it does cover others if you're in their jurisdiction.
Excellent point. Good. Any other comments before we just touch on CCPA and then we'll, of course, go into a panel discussion shortly, but any other comments before we move on?
Nope.
Yeah, actually, one really important comment on GDPR is the fines for misbehavior are very, very expensive. The Europeans have basically taken an approach of they understand businesses and organizations use a risk-based approach to whether they do data protection or not. And so they've made the fines so steep that it's cost-effective to do the right thing. So that's a big change. The other thing is the predecessor directive from 1995 meant that each country could implement what they thought was appropriate as a regulation. This applies. This is the minimum for every country in the EU. You can go beyond this, but they set a minimum. So this was a pretty radical change when it was implemented.
Yeah, that's a good point. Good. And a little bit about CCPA. In the California Consumer Privacy Act. So we're by the way, just going to refer to it as the CCPA from here on in, just because it's easier to say. Sort of a mouthful. That actually, technically, it actually goes into effect as a law on January 1st in 2020. So that's coming up very shortly at the beginning of next month. They have the term personal information, so you'll see PI. We'll probably just use the acronym PI from here on in. You notice we were using the term PII before. That was generally found in the GDPR regulation. Conversely, in CCPA, they tend to use a similar term, but a little bit different in PI, or personal information. So you'll see that referenced quite a bit when we're talking about CCPA. So, basically that personal information, again, generally names, phone numbers, addresses, and so on, anything that's collected. Obviously, it's companies that are doing business with California citizens. There seems to be this huge area where people are asking, I'm noticing it from the people that I interact with, is the question coming up, well, is CCPA only those businesses that are physically in the state of California? And definitely not. I mean, it's any company that deals with California citizens. In other words, you don't have to be a company that is residing or headquartered in California to be a part of or be touched by the CCPA. I'll stop there because I think there might be some interesting comments there from either Eric or Stephen.
Yeah, Stephen, I'll let you jump in there because I know you've got some customers you're dealing with here, or clients. Uh-oh, did we lose you? So, Thomas, just to follow up, we're definitely seeing businesses who are essentially have online services and whatnot. They're not, as you said, they're not based in California, but because they're engaging California citizens, they are potentially impacted by this. But unlike GDPR, which has, explicit fines for this behavior, the CCPA doesn't have that. So how one sort of reaches out and touches someone who is outside of California, could be a little challenging.
Yeah, absolutely. To say the least, could be quite challenging. And one of the things we wanted to focus on, again, is that right to be forgotten. This is actually listed in a couple of different recitals within the GDPR as the regulation. I mentioned those articles here, the recitals and the Article 17 specifically. And basically, the idea is that as a data subject, you have the right to basically request erasure of your personal data. Now, there's conditions that apply here, so we don't really have time to go through all of the conditions where there are exceptions and so on, and because that exception list is actually kind of long in and of itself. But the other interesting thing is the fact that there's this concept of undue delay, considered to be about a month, but there's a little bit of ambiguity as to how much time the organization has that has your data. But there are some specific time frames where you have to respond to a request for deletion. So
I'm back. I am so sorry. I don't know what happened to my connection, but it just blew away.
Oh, no problem. No problem. Eric and I were just chatting about this. We've gone on to the GDPR and the right to be forgotten specifically. Eric, you were going to say something on this one?
Yeah, on this right to be forgotten piece, it's important to note for GDPR that it actually applies to all entities. So it's, businesses, but it also applies to the government. And so they've actually, they've had to be kind of careful about the wording on this, because they didn't want, for example, the tax organizations in the respective countries to be hit with notices to eliminate information, which would then prevent them from being able to tax the citizens. So this is one of the big differences between GDPR and CCPA. So any of this identifiable information, which in itself is much broader than California, and it's not limited to businesses. It's literally organizations, and they don't really necessarily care why you're collecting the information, where in the case of California, that actually plays a role in terms of whether you can make it go away or not.
That's an interesting point. Tends to be much more broad in GDPR in its, let's say, its touch points, if you will, than CCPA.
Yeah, so we sometimes refer to CCPA as definitely GDPR light, and probably more light than I think a lot of people actually think.
Sure. And I think earlier, Eric, you were mentioning that, Stephen may have had, a few clients that are California specific that might be potentially dealing with CCPA in the near future, since it's going into law next month. Stephen, did you have any examples that obviously wouldn't share specifics because under non-disclosure, but any specifics of items that you might be dealing with?
Yeah. Some of the categorizations, I was talking after we got cut off, so, let me try to renew my comments. This is a work in progress, and it's going to be a work in progress even after January 1, because nobody really knows what eventually will be acceptable, not acceptable, what language, what placement. This is all very fluid, and right now, it's almost, you can almost hear the drum roll as to say, okay, who's going to be out of the chute first, and how are they going to make their disclosures, and more importantly, what disclosures are they going to make, and then more importantly, how these disclosures and how the rights given by the CCPA to California residents will be conveyed online. One interesting thing is issue is that if you have, the statute is California resident specific. Unfortunately, if you're in Ohio and you have one California resident and you have more than 25 million in revenues, you have to comply, arguably. And then, if you have 500,000, customers who are non-California residents and 10 who are you going to calve off that capability, or that the ability to make all the opt-in or opt-out, request to delete, request to access, right to know, do not sell options available globally to everybody, or are you going to try and restrict it to California residents? And in reality, what I'm seeing is that it really doesn't make any sense to restrict it to just California residents, because really it's going to cause more back-end administrative headaches trying to figure out who is, who isn't. I mean, there are things you can do for filtering, but again, on your website, you really want to say, oh, Californians have this right, but you don't. So these are some of the things that we're looking at. And again, the way that the language is conveyed, the format of the language, some of it's formulaic, some of it's not. Some of it's going to, take some time to evolve. And this is some of the things that we as lawyers are facing. And then, of course, you'll have lawsuits, which will basically help define what is absolutely not acceptable. But that hasn't happened.
Yeah.
Yeah, and Stephen, just to pick up on that, I mean, and again, this is a big difference between CCPA and GDPR. It's, you've got effectively the Attorney General of California is likely to weigh in on this. So I know in the early phases of GDPR, they were looking for a couple of organizations to burn, to basically drive home the point, and they did, and continue to do that. In the case of California, it's going to be interesting to see how the Attorney General, sort of steps forward to sort of make the point that you need to pay attention to this, because short of that, then it really comes down to I'm not a lawyer, but was it the right of private action or whatever? So basically, you can bring a lawsuit, but that's a little bit more challenging than having somebody do it on your behalf.
We have, in following up on what Eric says, what Eric refers to as a private right of action. In other words, does it allow private citizens to bring lawsuits, which would most likely be in the form of a class action lawsuit, even though the right to a private action is fairly limited under the CCPA. There are ways to incorporate other laws in conjunction with the CCPA to provide for ways to litigate, the CCPA kind of through a back channel. And without getting into the legal niceties of it, that's where the potential liability lies. You may not be caught up by the Attorney General for 2-3 years. The look back period only begins next year, not in 2021, not 2020. But lawyers who are looking for businesses that are violating CCPA, they're going to start January 2nd. Probably because January 1st they're just getting over their hangovers.
Euphoria.
Yeah.
Or something like that.
Yeah, something like that. Yeah. Interesting. Yeah, I would imagine that there would be within that first year or so, based on whatever legal happenings take place, that there would be some potential changes to the wording of the law just because of some of its ambiguity. I don't know. I'm just speculating.
Yeah, there's likely to be some clarification that comes down. I think in sort of conversations that were sort of leading up to the session today, looking at some of the specifics, there are some exceptions that have been included that, in the case of this right to be forgotten piece, you could essentially drive a Mack truck through the California version of what first of all, as a company, how you could essentially sidestep having to worry about this. GDPR, on the other hand, not so much. In fact, a lot of companies who are multinationals and have been, dealing with GDPR for 2 or 3 years, they're very little that they're going to actually have to do to actually get ready for CCPA. And in fact, tweaks to their notices and whatnot. But I can tell you, I know of companies that have had to relocate help desks, because even for their internal personnel who are in Europe, because they just needed to avoid lots of complications within their IT infrastructure. So anybody that's multinational dealing with GDPR has already sort of addressed some of this. Now, that said, there are a lot of businesses that are just based in the United States. This is going to be kind of a bit of a shock for them when they start looking at what they've got to do. Because, just simply this piece of making stuff go away, I mean, you've got to be able to interact with the individuals. You've got to be able to find what you've got. You've got to know whether you really truly can make it go away or have to make it go away. You have to be able to respond back. So there's, if you've never kind of looked at this before, you may actually have to make some pretty significant changes in your back office operations to be able to deal with those. And I know, Stephen, as a lawyer, you've been dealing with things like policies that organizations have to worry about. Is there anything that sort of pops out at you on the policy side that's pretty different on this?
For either GDPR or CCPA or
CCPA in particular. GDPR is really nasty, I know, from a policy perspective. But
CCPA has some road, has some mind traps, whatever they are, landmines. I got it. There are some problems that you'll encounter with CCPA as well. It's okay to have your website say that you're doing things, but then you have to create links within your website that are form specific in order to permit users to make the requests that request to exercise the rights that CPA grants to California residents, or let's just call them users. And you have to, not only do you have to have the links, but they have to be legible enough. They have to work. And if you're sloppy and they don't, that'll give somebody an edge to perhaps litigate. And then you really have to have a policy about not only, okay, we have the website has the request form, and the request forms get sent to we never pay attention to our email.com, at we don't care.com, right? You're going to have to, you then have to have an internal process to address the requests that are made. There are 4 different types of requests that can be made. And you have to have some sort of system where right now it's only proposed, but you're going to have to log the requests and the responses there too for a period of 2 years, right, which are also permitted under the CCPA. And with the whole idea being that you have to be able to demonstrate your compliance. And if you can't demonstrate and every year you're going to have to say what it is you do, what it is you keep, what type of information you're actually collecting by category, which means you may have to revise your website, your online disclosures and presence every year, depending upon how your business model changes. So to say this is dynamic is an understatement, but you also have to have the staffing, the toll-free number, what you should, you have to provide for the back-end compliance efforts that the front end indicates you are doing and demonstrate that you have done it. In other words, so for example, how do you know that wouldn't you rather have, if you have a 10-day response, an acknowledgement period, you want to log the 10-day acknowledgement of the request. You want to have a 45-day some sort of alert so that you know that there's a 45-day limit within which you have to respond with the information or with the information less whatever can be withheld. Or you have to have a within 45-day notification to a notification that you'll need an extra time and a reason therefore. So again, this is a fluid situation.
Yeah, and picking up on that, Stephen, one of the things I find kind of fascinating in CCPA, and I don't actually remember seeing any of this in GDPR, is that there's a lot of concern about effectively having information leaked to not the user, as you said, and could result in identity theft and whatnot. So there's this verification component, especially if the arrangement with the user isn't something like a password protected account. So you're not actually using some sort of authentication mechanism. So before you actually disclose any details, you've actually got to go through and deal with the verification. And that verification dance has to happen in that 45-day period. It doesn't start after, the verification. So there's a little additional.
There's an argument. There's an argument, Eric, that you have to do it within 10 days. It isn't. You can make the argument that an acknowledgement indicates that yes, we have received it. Now, unless you put in the, and again, this is where we're dealing with the unknowns. Unless you put in the acknowledgement, condition upon our verification of your request, we will respond within, an additional 35 days.
That's an interesting point, because I would agree with you that the way the CCPA is written, there's some fuzziness. There's a fascinating companion document, if you're into this kind of stuff, that talks about the intentions of the law and why they were making certain adjustments to it. And so this is one of the areas where they talk about sort of responses, because and responses take a couple of forms. So there's the response, so the right to know, basically, and then the right to delete. And it's not actually worded as the right to, but it's essentially, you have the ability to say, what do you got on me? And then delete it. And those can actually take the form of a single request, or it could take sort of two requests, and in this sort of explanatory material, they talk about the verification process and the timelines in terms of what a business has to essentially deal with. But it is fascinating that some of that language isn't explicitly covered in the actual CCPA law. So I think we're going to see, this is the part where they may go back to some of that original intention detail, and it's either going to come out as sort of advisories from the Attorney General, or they may actually end up going in and amending the law to add a little more of this. So yeah, it's definitely going to be interesting to see who gets toasted first, and then what the ramifications for that are going to be.
Well, not only who gets toasted first, but by whom?
Right. My speculation is that it'll probably be the Attorney General, just to basically get everybody's attention.
And I'll bet that it's a plaintiff's firm.
Okay, so we got a lunch thing going here.
Well, actually, you're being unfair to yourself, because the Attorney General is only going to start looking a year out. It's only going to start looking back 2021, January 1.
Maybe. It depends on the election.
We'll see.
They actually have to show that they're doing something in office.
One thing we also have to keep in mind is that, and I'm not sure this is necessarily going to be the case this year, or maybe even next year, is that the federal government, Congress keeps on floating a federal privacy law every now and then, and whether or not, whether and how that privacy law is drafted might wind up preempting every privacy statute on the books in every state. But we don't know that for sure. If the statute is written like many statutes, it will preempt or will impliedly preempt. If the statute is written like HIPAA, it will not. It will supplement.
That's an interesting comment because until recently there was not really any sort of indication that Congress would do that. I was on a call with the American Bar Association's Cybersecurity Legal Task Force recently, and one of the individuals tracks what's going on in Congress, and he made the comment that there had actually been some hearings last week that in the midst of all the other fun that sort of hinted that they may be taking this much more seriously than they have in the past. It's not clear if things like CCPA is serving as kind of a forcing function, but it might. I mean, because I think there's a lot of concern about, if California goes down this path, there's another set of states that have done similar things. If you look at, Massachusetts, Nevada, for example. Yeah, Nevada. I mean, there's a bunch of states that they don't always follow exactly what's going on in California, but there's sort of a close enough that it can be a real pain for businesses. And, and the bottom line is CCPA is really business focused. That's the thing that, unlike GDPR, it really is.
Which is individually focused. Yeah.
Yes.
Yeah. So I guess, Eric, the way that you would characterize what you said, the way I would characterize it would be that CCPA is focused on what businesses need to do, while GDPR focuses on the rights of the data subjects, those individuals who are covered by the GDPR.
Yeah, exactly. I mean, it is an inalienable right. I mean, the EU, just for historical reasons, this is they are almost as focused on privacy as we are on gun rights in the United States.
Yeah, that's always an interesting analogy, to say the least. True, though. I mean, true in many respects. What I'll do is I'm going to do a couple of key takeaways from the briefing part, and then we'll continue the discussion on the panel side. So on this slide here, some of the takeaways at a high level would be making sure that from a business perspective, do you know whether or not your business specifically falls under the scope of the new laws? And that would be something to make sure you review with your legal staff. The next one is implementing transparency. Actually, Stephen was alluding to this about, stuff that you have to have on your website and making sure you're transparent. And by the way, do the links work if you do have the links? I mean, it's quite a bit of information that these respective businesses have to do. And then next would be the timely response. There are some pieces of the legislation that focus specifically on timing and how quickly you do have to respond. And we sort of touched over some of those throughout this, but they're quite specific, and in some cases they're not so specific. But there are some issues with making sure you respond to specific requests that you have to make sure you're abiding by from a company perspective. Next is managing objections and how you do erasure requests and making sure you're not discriminating and making sure that you're appropriately vetting the requests that are coming in. And Eric was sort of alluding to making sure that that's taken care of as well. That is it authentic. In other words, you're doing a request for your data to be deleted. Are you really who you state you are? And so there's a whole bunch of things that you have to make sure that you have to account for as a business. And lastly, the non-compliance. Are you doing all the things that you're supposed to do based on the law? And if you're not, then being subject to potential penalties or additional litigation. So those are some of the key takeaways at a high level. And what we'll do is we're sort of going to move over now to the official panel discussion, even though we've been doing quite a bit of good discussion already. You'll see the list of the folks, again, me, the Thomas moderator on the left, and then panelists being Eric and Stephen, who you've already heard from, both. So without further ado, what we'll do is move to a panel discussion for the audience. This is your opportunity to ask questions. You will see the Ask a Question button on your screen, so feel free to submit questions to us. As the moderator, I will moderate the questions, make sure that we keep the flow going, and answer questions from the audience as they come in with the remaining time that we have. So, in fact, we already have a couple of questions coming in. So, the first question being, from a legal perspective, and I guess this would be for Stephen being the attorney on the panel, the first question that came in is, as you see CCPA from a legal perspective, and from the rights of what you would potentially see from other citizens that are not necessarily in the state of California, how would it affect others, if at all, as CCPA is currently written? In other words, do you have to be, by definition, a citizen of the state of California as a person? I'm not talking about the business, but as a person to be affected by the CCPA specifically.
By all appearances, the answer is yes.
So, Stephen, let me follow up on that. So that's a potential filtering mechanism then that companies could use. As they're like, hey, how are you?
It is,
and
of course it is. But think of the way it looks on a website when somebody says, "What do you mean I can do that, but you can't?" Or California. It sets up a dissonance when you visit a website for an arguably pleasurable experience to be told you can't do something. What do this is something we've thought about, we've discussed, not thought about, which is, do you put California residents only, see this, or your rights as a California resident, other residents need not apply, other states' residents need not apply. You have to think of the practical effect of the type of filtering you might or might not want to do, and then say to yourself, is it more resource intense to do the filtering than not? Sure, and then how do you'll have, and then what are you going to have in your disclosure? I hereby verify that I'm a citizen of the state of California. And if you say no, you got bounced out of the form. It not only does it make it inclusive, it's almost as if you're flipping the bird to your consumers. And does it really make a difference? And looking at the way that things are going to go in the future, does it really make sense to restrict it only to Californians? And I'll follow up on my own comment. And in the end, given and this is, you have to look at the American versus European perspective. Given the Americans' perspective, how many people are even going to bother? At least for the next 5 years.
Yeah, I think that's an interesting comment. I mean, we are so used to giving it up when it comes to details. Oh look, I'm going to get this wonderful service. Not so much. If I give away everything.
But here's where it gets more interesting. All right, and this is where I look at this as being, a potential time bomb. So if you operate, you sell a good, right? You sell a connected device, like a TV, for example, or a thermostat, for example. And the part of what your TV manufacturer provides an in-tube or an in-picture means of accessing streaming services. And it's an application, just like any other. And you have to register for it, just like any other. But you also have to accept their terms of use in order to use the application that's embedded in the TV, in your TV, in your large screen TV. If you don't accept, you can't use the service. You can't use the built-in streaming capability or the access to the streaming services.
That's a problem under CCPA.
Wait, we're not done. Well, we're not done. You have a thermostat, connected thermostat, and your thermostat requires that you do the same. What then? All right, and let me let Eric respond to that.
Yeah, so definitely the CCPA gives you the ability to opt out. So you've got to factor that in. But there's also language in the CCPA about sort of the financial incentives to giving it up. So there's some unhappiness. The authors basically were not happy about the fact that if you give up all these details, you get a 5% discount or whatever. So there's definitely language that they're trying to sort of deal with that situation where the company is not basically exploiting the users, as you call them, and so yeah, this is
a service to them. We're providing a service to them. Oh no, we're not exploiting them.
I think the line is we are servicing them. Yes.
Yes. And one thing, and you have to look at it this way, and you say to yourself, well, it's a violation. Not only is it a violation of the CCPA, arguably, and I think the CCPA makes provisions for paying you actually for giving your information, but again, it's kind of what we call it's a take it or leave it contract, a contract of adhesion, maybe. So, accept this money or don't use this, or we're not going to let you use the service on the TV. We're not going to let you remotely shut your garage door. We're not going to let you remotely adjust your temperature in your house unless you agree to these terms and conditions, which means that we can share, quote unquote, our, de-identified information about you with our partners, or whatever they call them, basically data aggregators. And so what we're
I was going to say, but you said a magic word though. De-identified is actually a permissible way of from a CCPA perspective of dealing with this as a business.
And if we can really get to the bottom of what de-identified is, when you're when you have enough data points about a user that you could basically knock on their door without too much investigatory effort, then maybe. But then but the issue is wider than that. So your data aggregator takes in quote unquote de-identified information, combines it with other quote unquote de-identified information, and you basically have your name, address, phone number, and how many dogs you own and their age. But the idea is that it's still your information that they're using, that they're selling, and I think the issue is as yet unresolved.
Right.
So and then what? So the question is, how might you get sued as a company for doing this? And of course, you have there won't be a private right of action under the CCPA, although arguably you could bring a breach of contract action. Of course, you might have to go to arbitration, and there might be a class arbitration clause, which would prevent you from going to court, but not necessarily your wife, your son, your daughter, who might not be covered by an arbitration clause, who might then bring a class action. We're not done quite yet. And then you might say, well, if it's not a breach of contract, well, maybe it's an unfair and deceptive practice because you're misrepresenting what it is you purchased when you did purchase. And maybe it's a conversion of information that is taken away from you and not or not being paid for. And there's whole bunches of things that you can wind up being dinged for from a legal perspective.
Well, that deceptive practice angle is kind of interesting because that's something that the FTC has definitely been employing for a while, and in fact, with sort of the cybersecurity space, if you're making claims about being secure, they're definitely happy to take some funds from you if it can be shown that, well, maybe we're not quite as secure as we thought we were. So having said that, do you see the feds being able to sort of intervene on something like this, even though it's a California law?
Yeah. Oh, they're using interstate. They're using interstate means of conducting business, i.e., the internet, and the FTC can easily step in.
Oh, that's an interesting angle. I hadn't, when you were saying that, it occurred to me because I've had quality time with the FTC in a positive way. Interesting discussions, and I wasn't sure whether they could be invoked. When they show up, organizations tend to kind of awaken because of the fines they can level.
Yeah, that's quite interesting. I have another question that just came in, and this is an interesting one. It has to do with de-identification. The question is this. We only have a few minutes left, by the way, but the question is, if you have a request to the company to have your data deleted, this is in the case of CCPA, and the company declares that your data, whatever that personal data is, has been, quote, de-identified, meaning it can't be related back to you, but you want that data deleted. Legally, Stephen, can that data remain, or do they still have to delete the data based on the request from the user?
Uh-oh. Well, I'm not Stephen, but sometimes I play the part of the lawyer.
Guys, I'm here, but I'm being barraged with some emergency calls from my client, so I need to withdraw. Ask me that last question. Let me address that, and then I'll have to log off.
Okay, no problem. So the question is, if you're de-identified, or you request your data to be deleted, and then the company says, oh, no, listen, I de-identified all your data, but the user says, no, I want that data deleted anyway, even though you claim it's de-identified. Does the company have to delete your data anyway, yes or no?
I don't see any exception. If they still have your unde-identified information anywhere, they're going to have to delete that. Are they going to have to delete the de-identified information? Maybe not, but if somebody gets aggressive and goes to court about it, then we'll have to await a court decision on whether or not that also needs to be ultimately deleted, depending upon how you define de-identified sufficient to evade California CCPA coverage.
Gotcha.
Yeah, I think, following up on that, there can be this multi-step, knowing what you have on me and then delete. As part of the knowing what you have on me, the de-identified information would not be provided to you. So there's no requirement to actually share that detail with you. So if they in fact had already moved to a de-identified state, the response back would be, we have no information on you. So you would never actually know that there's they've taken that step, unless they actually said, well, we take all the information and we de-identify it, and as such, we have no information on you. That would be, a potential response, but I'm not sure that they're even obligated to basically say that. But it's pretty clear in the CCPA that if the de-identified information does not have to be deleted.
And
I'm
generally in agreement with that. Gentlemen, I do need to sign off. I apologize, but if anybody asks any questions for post webinar, I'm happy to respond to them as well.
Great. Well, thank you both. And we're at the end anyway, so my only request to the audience is please take a few moments to rate the value of today's webcast. There is a button on your screen that says Rate This, so please click on that Rate This button and let us know how we're doing. And thank you all for joining today. We appreciate your time, and we'll talk to you soon. Take care. Bye-bye.
Thank you. Bye-bye.